walking into a local gun show, not as a buyer, but as an investigator for a major federal agency. You're not looking for someone selling a stolen firearm or a convicted felon in possession. You're looking for a grandparent, perhaps a retired veteran who has decided to downsize a collection, or an enthusiast who simply wants to sell a few rifles to fund a new purchase. Under a rule finalized just last year, that grandparent, if they sell one too many guns from their personal safe, could be classified as a dealer, facing the very real threat of federal prosecution and a 5-year prison sentence. This isn't a hypothetical scenario cooked up by internet forums. This was the reality of the ATF's 2024 Engaged in the Business Rule, a regulation that blurred the line between a constitutional right and a federal crime until a federal court struck it down just this past October. So, here's the question I have for you today, and I want you to answer it honestly in the comments. If you decided to sell 3 firearms from your personal collection this year to reinvest in a new model, do you believe you should be required to register as a federal firearms dealer? Or does that feel like the government treating your private property as an inventory? That tension between lawful ownership and accidental criminalization is the exact fault line running through American jurisprudence right now. And it brings us to the topic at hand. If you own certain types of firearms, or if you engage in certain types of transactions, you aren't just a gun owner anymore. You are a participant in one of the most dynamic and rapidly evolving areas of constitutional law since the 1960s. You might be sitting on a hidden fortune, not necessarily in the financial sense, but in the legal sense. You might be holding a piece of property that federal courts are actively redefining as beyond the reach of government power. We have to start with a fundamental shift in how courts analyze these questions. For decades after the Gun Control Act of 1968, the conventional wisdom was simple. If the government wanted to ban a certain type of weapon or restrict a certain type of sale, they could do so as long as they had a rational reason. That era is over. It ended definitively in 2022 with the Supreme Court's ruling in New York State Rifle and Pistol Association versus Bruen. Now, if the government wants to regulate your firearm, they have to play a game of historical chess. They have to prove that the regulation is consistent with the nation's historical tradition of firearm regulation. This is the test that is reshaping the legal landscape. It's the reason why a federal judge in Alabama looked at the ATF's new rule and said, "No, Congress didn't authorize this." In Butler versus Bondi, decided in September 2024, the court dismantled the ATF's attempt to redefine what it means to be engaged in the business. The Bipartisan Safer Communities Act changed the wording from requiring a livelihood and profit to requiring a predominant intent to earn a profit. The ATF took that ball and ran with it, issuing a rule that suggested even a single transaction could require a license, and specifically excluded guns purchased for personal protection from the definition of a personal collection. Think about the implications of that exclusion for a moment. If you bought a shotgun for home defense, under that rule, the ATF argued that gun could never be sold as part of a personal collection sale without a license. That defense shotgun was legally tainted for resale from the moment you bought it. The court saw this for what it was, an agency rewriting criminal law. They issued a permanent injunction. This means that if you are a member of the NRA or fall within the class of plaintiffs in that case, your ability to sell your collection without federal interference is protected. This brings us to the first category of firearm owner who holds a uniquely protected status right now, the private collector. Specifically, the non-licensed private individual who buys and sells from their collection. The legal battle over the engaged in the business rule is a perfect example of why you need to understand the distinction between as-applied challenges and facial challenges. The ATF's rule was struck down on its face, meaning it was invalid across the board, because it contradicted the statute passed by Congress. But why does this matter to your wallet? Because scarcity created by regulation drives value. When the government threatens to classify private sellers as dealers, it chills the market. People become afraid to sell. They sit on collections. But when a federal court steps in and says, the ATF cannot redefine your private transaction as a commercial enterprise, it liberates that property. It confirms that the firearms sitting in your safe are not a regulatory gray area. They are constitutionally protected property. Moving beyond the transactions themselves, we have to look at the hardware. The second category of owner who might be sitting on a legal treasure trove is anyone who owns non-traditional arms, specifically items like stun guns, tasers, or other electronic defensive devices. In 2016, in a case called Caetano versus Massachusetts, the Supreme Court issued a unanimous, albeit brief opinion that sent shockwaves through the lower courts. The court struck down a Massachusetts ban on stun guns, holding that the Second Amendment extends to bearable arms that were not in existence at the founding. The court was explicit. The protections of the Second Amendment aren't limited to the muskets of 1791. If you own a stun gun, or if you own a modern semi-automatic handgun that was manufactured after 2000, you are holding an item that the Supreme Court has explicitly stated falls under the presumptive protection of the Constitution. But here is the catch. The fortune lies in the litigation risk for the government. States like Hawaii, New York, and New Jersey have tried to impose sensitive places restrictions that make it impossible to actually carry these protected arms. Right now, the Supreme Court is hearing arguments in Wolford versus Lopez, the Hawaii vampire rule case, where the state tried to ban licensed carriers from private property open to the public unless the property owner explicitly said yes. During oral arguments in January 2026, Justice Kavanaugh cut to the heart of it, stating that the text of the Second Amendment covers arms, and if there's no historical tradition for a regulation, it fails. Justice Alito pointed out the absurdity of the state relying on racist black codes from the antebellum South to justify modern gun bans. If you carry a firearm for self-defense, the legal protection for that act has never been stronger. The fortune isn't just the gun, it's the right to carry it where you go. The third and perhaps most volatile category involves items that aren't even fully assembled yet. If you own 80% receivers or buy, build, shoot kits, you are sitting at the epicenter of an administrative law earthquake. We touched on the Vanderstock case earlier. This case, Bondi versus Vanderstock, challenged the ATF's rule that tried to redefine these unfinished pieces of polymer or aluminum as firearms, subject to serialization and background checks. The Supreme Court recently issued a ruling that, on the surface, seemed like a win for the government. But legally, it was a mess. The court applied a standard called facial review, asking whether the rule was invalid in all its applications. They found it wasn't, because in some cases, a kit might be so close to completion that it counts as a gun. But here is the hidden fortune for owners. Justice Alito, in his dissent, warned that the majority's logic was a huge boon for the administrative state, not a restriction on it. However, legal scholars at the Yale Journal on Regulation have pointed out that the court's analysis was shallow. It essentially dodged the big question. Does the ATF have the authority to regulate these parts at all? If you own these kits, you own an item that is currently in regulatory limbo. The government claims it's a gun. The manufacturers claim it's a piece of metal. The Due Process Clause requires that a person of ordinary intelligence know when they are breaking the law. Right now, with the lower courts split and the Supreme Court refusing to clearly define the line, the legal risk for the government in prosecuting an owner of a true 80% receiver is astronomically high. That ambiguity is a form of protection. It means that prosecutors are likely to avoid bringing cases that could create bad precedent, leaving these items in a legally gray but practically safe zone. We also have to address the invisible fortune, the legal status of the person holding the gun. The Supreme Court is currently grappling with United States versus Himani, which asks whether the federal ban on gun possession by unlawful drug users, specifically marijuana users, is constitutional. The Fifth Circuit has already ruled that disarming a sober marijuana user has no historical analog to the founding-era bans on habitual drunkards. The government is arguing that these bans are analogous because they deal with intoxication. If the Supreme Court rules in favor of Himani, the implications are staggering. It would mean that millions of Americans who use cannabis in states where it is legal, but who are not impaired at the time of possession, could have their gun rights restored. If you are a gun owner in a legal marijuana state, you are currently a felon in waiting under federal law. But if the historical test in Bruen is applied honestly, that law is standing on very shaky ground. Your fortune in this case is the potential restoration of a right you may have thought you permanently lost. The fifth category involves those who own firearms that were previously banned by state laws that are now being dismantled. Look at the Fourth Circuit, the Third Circuit, and the Fifth Circuit. They are actively reviewing assault weapons bans. While the Supreme Court hasn't taken a blanket ban case yet, the reasoning in Bruen suggests that if a weapon is in common use for a lawful purpose, like self-defense, it cannot be banned. The AR-15 platform is the most popular rifle platform in America. That is the very definition of common use. If you live in a state like Maryland or California and you own a firearm that the state labels an assault weapon, you are part of a massive class action lawsuit waiting to happen. The legal arguments against these bans are becoming stronger by the day. If the Supreme Court eventually applies the Bruen test strictly, these bans could fall, and the restricted weapons could become highly sought-after collectibles overnight, simply because they were previously unavailable. Let's shift to the industry side. If you own a firearms manufacturing company or a retail store, your business model is currently protected by the Protection of Lawful Commerce in Arms Act, or PLCAA. This federal law prevents gun makers from being sued when criminals misuse their products. Recently, New York passed a law trying to carve out an exception, labeling certain industry practices a public nuisance. The Second Circuit upheld this law on its face, but as the Harvard Law Review noted, the concurring judge warned that applying this law in a way that creates concrete duties will be nearly impossible without running into PLCAA's protections. If you are an FFL holder, your protection from predatory litigation is written into federal statute. The attempts by states to bankrupt the industry through litigation are facing massive constitutional hurdles. That stability adds long-term value to your business and your inventory. We are living in a period of maximum legal uncertainty, and for the savvy gun owner, uncertainty equals opportunity. The Bruen decision established a floor, not a ceiling, for rights. It said that the government cannot infringe on conduct covered by the plain text of the Second Amendment unless they have history on their side. As we've seen in Rahimi, where the court upheld the disarmament of domestic abusers, the government can meet that burden if there is a clear historical tradition of disarming dangerous individuals. But for the law-abiding citizen, the historical record is sparse. What does this mean for you? It means that the value of your collection is no longer just about ballistics and finish. It is about constitutional viability. A firearm that is legally controversial today, like a pistol with a stabilizing brace, or a suppressor, or a high-capacity magazine, might be the subject of a landmark ruling tomorrow. If the courts strike down the regulation, that item is no longer just a gun. It is a symbol of a constitutional victory. But I have to give you the warning that any legal analyst must give. This is not a green light to break the law. The ATF still enforces the laws on the books until they are struck down. If you are relying on a pending Supreme Court case to justify possession of an item currently banned in your jurisdiction, you are playing a very dangerous game. The legal concept of good faith reliance on a court ruling usually requires a final, unappealable judgment that directly applies to you. So, as we watch the arguments in Hamani and Wolford unfold, and as we wait for the final word on these challenges, ask yourself, do you know the legal status of what you own? Do you know if your state law conflicts with the historical tradition test? If you can answer those questions, you aren't just a collector, you are a constitutional stakeholder. Let me leave you with 3 takeaways to consider as you review your own situation. First, the legal standard has fundamentally changed. We are no longer in a world of balancing public interest against individual rights. We are in a world of text, history, and tradition. If a law didn't exist in the 18th or 19th century, it carries a heavy burden today. Second, the definition of arms is broad and expanding. From stun guns to unfinished receivers, the Supreme Court has signaled that modern instruments of self-defense are protected. If you own technology that the government is trying to regulate through agency fiat, you may have a winning argument in federal court. And third, your status as a lawful citizen matters more than ever. The government's power to disarm you hinges on proving a historical tradition of disarming people like you. As the Rahimi decision showed, that tradition exists for the violent and the dangerous. But for the sober, law-abiding citizen, the historical record offers the government very little support. Thank you for watching. If you found this analysis useful, please subscribe and let me know in the comments. After hearing about the ATF's attempts to regulate private sales, Do you believe the line between a collector and a dealer is clear enough? Or do you worry about accidentally crossing it? That is the question only you can answer, and I look forward to reading your thoughts.